The New York City Human Rights Commission has actually put out 4 legal enforcement guidance documents in the past year. They've been on criminal checks, credit checks, gender identity, and now on pregnancy accommodations. Pregnancy accommodations have been required in New York City since 2014, but because of the broad mandate from the New York City Human Rights Law, the Commission has been putting forward legal enforcement guidance in order to show how it expects courts and employers to handle any types of accommodation requests that come up. New York City's pregnancy accommodation law is similar to a lot of other laws that have been passed in that New York City employers have to provide an accommodation whether or not the pregnancy has resulted in a disability. There's many other locations that say that you must have a disability in order to get the accommodation. But in New York City, the mere fact of being pregnant or trying to get pregnant or post-pregnancy disabilities are enough to require an accommodation. This publication creates a new term for us to use now. Instead of the interactive process, which we normally have thought about in the past when it comes to accommodations, thinking about disability, pregnancy, religious beliefs, we now have this new word called a cooperative dialogue, which is the exact same thing as interactive process. It means that when the employer finds out whether an accommodation is needed, whether someone else has told them, whether the employees told them, whether it's in writing from a doctor, the employer needs to engage with the employee and try and figure out what the best accommodation will be. It's really important from these guidelines to document the entire process. And at the end, if an accommodation is found, that needs to be put in writing and provided to the employee. Just as importantly, if an accommodation is not found, then the employer should document that to show that they've gone through this cooperative dialogue.